Good morning, everyone. We have a new addition to the board. We have microphones, so I guess you guys can hear me actually a little clearer this morning. Call this meeting to order this morning. I want to welcome each and every one here. The board has just come back from a very successful Victims Visitors Day that we have in Lumpen County. I want to thank all of the employees, both Clemency as well as our Office of Victim Services, for participating in that. A lot of people were served. Well over 100 people met with the board during that time, and it was quite a successful event. For those of you who are not aware of that, who are watching by video, the board engages in the Victim Service Day 2 times each year. We make it possible for every registered victim in the state to have an opportunity to speak directly to a board member at least 2 times each year. Is there any remarks any other board member want to make at this time? If not, then we'll get right into our work. The agenda is before you. They were emailed to you, so each person should have had those. We will need to accept the motion and a vote on the agenda. Is there a motion to adopt?
Move we adopt.
There's a motion. Is there a second?
Second.
There's a motion. There's a second. All in favor say aye.
Aye.
Hearing none, the agenda has been adopted. You also were emailed your minutes from our last board meeting, which was March the 7th. Looking through those really briefly, if there's any additions or corrections that need to be made on those minutes, speak up now. Otherwise, is there a motion to adopt?
Give your motion.
There's a motion. Is there a second?
Second.
There is a second. All in favor say aye.
Aye.
Hearing none, motion carries, so the minutes have been adopted. One item of business that has been carried over from our last board meeting, and I just noticed that I failed to call on Anita to pray for us. So I guess what I'll do is, before we'll do that, I will just pause for a moment and do that and catch up with that. We typically do that right after the welcome, but in this case, since I overlooked it, I want to just pause for a moment for that. Anita, would you come and offer a prayer for us?
Good morning. Let us take a moment to reflect as we find ourselves in the midst of this week of love, passion, and sacrifice. Let us pray. Heavenly Father, we come before you this morning, just lifting you up and magnifying your holy name, thanking you for the awesomeness that you have presented us in ways of blessings, grace, and mercy. We ask now that you look upon us and forgive us for all of our iniquities, that you move amongst this meeting, Father God, so that it is pleasing to you. We stop and pause to thank you for the ultimate sacrifice that gave us a beginning to what we would call our mortal ending. So we lift you up and we ask your blessings upon this parole board. We ask your blessings upon this parole family, for all who are gathered here. Blessings upon our state, and blessings, Lord God, upon our nation, that we not forget that you commanded us to love our neighbors as ourselves. In the name of Jesus, we lift up this prayer. Amen.
Thank you, Nita. Okay, moving now into our old business. Last board meeting, the board provisionally adopted a rule change, new rule change that affects our guidelines policies in the state. That rule change amendment is a 475-3.05. And at this time, I'm going to go back and yield to Quan, our board's attorney, to make at least a brief presentation as to what that rule change in effect will do. And then after she's done that, we will then go to public comments and see if there's public comments on that before the board determines whether to take action or not today. Quan.
Thank you, Mr. Chairman. Good morning, board. As you recall, last month you voted provisionally to adopt proposed changes to our guidelines. Among those changes included grammatical changes, some commas throughout, or some more proper grammar usage. Also, we're looking at changing the risk instrument to one used for males and a separate one for females. The factors and respective weights will also change for both groups, males and females. We will utilize current primary conviction offense being is a property crime. The current prison admission type is a parole or probation revocation. Number of prior felony arrests and number of prior misdemeanor arrests will also be factors, as well as the age at current prison admission and whether the offender has received a violent DR charge during any incarceration period within the Department of Corrections. One difference between, and the only difference between the male and the female risk instrument is that for the males, there will be a factor whether they are a validated gang member. The other changes are related to crime severity levels. Level 8 will be adding trafficking and sexual and labor servitude where the victim is under 18 years of age and it's a coercion or deception involved. Also adding trafficking and sexual or labor servitude where the victim is developmentally disabled, that is at any age. And we will also be removing burglary of an unoccupied or vacant dwelling, changing that to a crime severity level 6. Crime severity level 7, we will be modifying the pimping or pandering a child under the age of 18 to make it at under the age of 16. Also adding trafficking and sexual or labor servitude any age where there's no coercion or deception. And finally, removing probation revocation based on a level 8 offense that will become a crime severity level 6. The crime severity level 6 will be adding pimping or pandering a child age 16 or 17. Also homicide by vehicle, where there's not a DUI or habitual violator, that is currently a crime severity level 4. Crime severity level 5 will be adding possession of a illegal weapon or explosives, that is currently a crime severity level 2, and adding criminal street gang activity. Also removing identity fraud, that will become a crime severity level 4. At crime severity level 4, we'll be adding possession of a firearm by a convicted felon under active supervision. Crime severity level 3, adding possession of a firearm by a convicted felon. And crime severity level 2, adding possession of a firearm during commission of a crime. There will also be changes to risk to reoffend scores in both the male and female instruments, as well as changes to months to serve recommendations as it relates to crime severity levels 5, 6, and 7. That concludes my presentation regarding the changes in the guidelines.
Okay, at this time, is there any questions from the members of legal counsel on the proposed rule change? Hearing no questions, let me mention this before I actually call on the public to make comments, that this issue has been on the board's, for lack of a better word's plate for some time now. I think if we were to wait till July, that would mark the 2nd year anniversary. Is that correct, Chris? We've been working on this for 2 years. Time has a way of moving along fast. Typically, the board would like to revalidate its guidelines every 5 years, but due to criminal justice reform, we wanted to see what the impact that also had on some of the decisions being made. So we gave ourselves a bit more time, and so for the last 2 years, we've had the scientists over at ARS to start working on this process. And so this is the work of a 2-year period that's brought us to this day. So for the public, I do not want you to think that we started this last month. It has taken a lot of work, and not only has it taken a lot of work, our staff has gone out into the streets and met with many of the stakeholders. I think pretty much everyone who has a part in public comments, in a sense, has been made aware of this by this time. If they haven't, then I'm not so sure why that's the case. But at this time, I do want to receive any public comments that anyone particular may have regarding the proposed rule change at this time. We're only interested in public comments on the proposed rule change. I think, do we have a couple that are signed up to speak? Is that correct?
I believe so. Mr. Chairman, may I interject? Up until this date, we've only received one written comment, and that's from Attorney Jody Dick. I believe she's here and is prepared to speak. But other than that, we've had no other comments submitted to this date.
Right. I have a copy of
Since the last board.
I do have a copy of Ms. Dick's letter, and the board did receive that yesterday, a very well-written letter. We appreciate that. Ms. Dix, do you wish to speak?
Thank you.
Would you like to come to the podium?
Well, actually, Chairman, if it would be okay, I would ask that Scott Key first address the board. He is speaking on behalf of GACTL.
Okay.
And then if I have any additional comments, perhaps I can supplement.
So what is his name again? Scott
Key.
Key. Mr. Key, would you come to the podium? I think the microphone's on there for you so that your comments can be part of our record today as well, if you will.
Thank you, Mr. Chairman. I would like to clear up one thing. The GACDL did submit comments back in October of 2016 that did raise some concerns that we think impact the rule change. And if that is not available and part of this process, we'd be happy to resubmit our October letter. It was our president submitted those back in October. And some of that impacts the rule change. Some of it impacts some more procedural things beyond that. And we could certainly supplement with that. And we appreciate what the parole board is doing. I think largely it seems like it's a move to more objective standards, and it seems like the process is potentially becoming more transparent. We do have a couple of criticisms.
Hang on just a second. We've got a little problem with some feedback. I don't know if that means the microphone's too loud or what. Do you have
I'm too loud.
is that what it is? Oh, my.
When I stood back from it, is that a little bit
Okay,
better?
good.
All right.
Yes,
I think
sir. This is our first run of this today, so bear with us as we try to learn.
It's completely my fault. So we'd like to first of all talk about the move to counting prior felony and misdemeanor arrests as part of the decision-making process. GACTL has some concerns that and I know that there are studies that say that arrests are potentially significant in terms of assessing someone's risk to reoffend and risk, in terms of their risk level on parole. We do have some concerns that it increases the likelihood that someone will be negatively or adversely affected by a false arrest, particularly if charges are ultimately dismissed or if a person goes to trial on that arrest and they're subsequently acquitted of that charge. They should not be negatively impacted by the initial arrest. It doesn't take much for someone to be arrested, and particularly in a warrantless arrest situation, someone can be arrested and potentially the warrant doesn't later issue. And so to count an arrest like that, I guess to look at all arrests as the same is somewhat problematic without perhaps having some process to analyze the complexity of what led to the arrest. We also have some concerns that factoring in arrests alone could adversely impact non-white arrestees, particularly African Americans. We do have some studies that we've reviewed. For instance, the 2009 Sentencing Project study indicated that African Americans as of 2009 comprise about 13% of drug users, but they accounted for 36% of drug arrests and 46% of drug convictions. And so if you look at data like that, it suggests the possibility and likely the probability that counting arrests as a negative factor alone without more potentially increases the likelihood that inaccurate data will be used to assess someone's risk to reoffend when they're released on parole. And I think it reinforces the mentality that if someone was arrested, that person must be guilty of something. And that is, our criminal justice system is not built on that assumption. We look for and we try to screen the jurors in voir dire that think like that, and judges instruct potential jurors not to think like that. And so, in fact, someone who believes that probably is not even a qualified juror. So we think it's problematic the extent to which the new rule would look at the number of arrests without more. That's our first concern. Our next concern is the move to, or the parole board's potential use of DRs and the idea of a violent DR being considered. And I'm not sure exactly if I'm interpreting this correctly, and I may not be. But it does not seem that the process would account for a DR that was not substantiated. I don't know if I know that there is a hearing process for DRs. I know that there's some due process afforded to an inmate, and there are times when DRs are dismissed before there is a hearing, and there are times when there is DR court and the DR is not substantiated. It appears, although I could be wrong about this, it appears that DRs would be considered regardless of the outcome of the DR court process and without regard to whether or not the DR was dismissed before it went to court. And we would have some concerns of DRs being considered for parole eligibility if those turn out not to be substantiated. The other part is that there is an emphasis on the concept of a violent DR in the proposed rule change. My understanding of how DRs are sort of sorted out now is it's either low, medium, high, or great. And if you look at what type of conduct lands you into the great category or into the high category, it's not necessarily delineated on the basis of violence currently, and it could be that the DOC changes in reaction to whatever the parole board's rule changes. I don't know the extent of the communication back and forth with DOC. But as it currently stands, for instance, insubordination or disrespect for an officer counts as a high DR. But insubordination or disrespect is not necessarily a violent act. It could simply be just the refusal to do something. And I suppose we could debate about whether that is really violent. If we are going to move to a category that adversely affects someone's parole eligibility based upon what a violent DR is, we would like to see some objective measure for what constitutes a DR, both so that we can know as lawyers representing clients what that means, and so that an inmate has notice of what, obviously an inmate should never commit a DR, period, and I understand that. But there should be some notice as to what constitutes a violent DR, and it should not be subject to the whim of whoever issues the DR or the DR court, because it could be that what the board considers to be a violent DR wasn't actually a violent DR if you unpack it, and it could be that those classifications are being made at the ground level where everyone's not on the same page and using the same terminology. And that's our concern about violent DRs. In terms of the gang membership piece, we do anticipate there being some potential problems in terms of a future equal protection challenge if only males are being considered for gang membership in terms of parole and females are not. And I'm sure that there is research, there's some research basis to that designation or that delineation or difference that the board intends to make. But there could be some equal protection if males are being considered adversely for gang membership and females are not. We have struggled to determine what exactly the process is that the DOC uses to determine to validate that someone is in a gang. Law enforcement at the arrest level often presumes gang membership, and sometimes that is not the case. Inmates and attorneys, well, first of all, we think there should be some detailed objective criteria used in determining or designating someone as a gang member. And inmates and attorneys should be notified of that designation and be privy to the information and the criteria used to determine that they were a gang member. And there should be a process in place where an inmate can challenge the validation that well, I guess not he or she, that he is a gang member. I know that we have made some attempts through open records requests to figure out how that process is done at DOC. And it could be that Ms. Dick has gotten to some of that. I know that she has gotten some open records requests material. She's gotten some. But we do have some concerns if gang membership is going to factor, that there be some objective process to determine what it takes to be validated as a gang member. And there should be some opportunity for the inmate to challenge that designation, considering that it is going to factor very importantly under the proposed rule if you are a gang member. So we have that concern as well. In terms of the risk to reoffend score, I think Ms. Dick has expressed in her letter some concerns about it being complex. And I think she's articulated to me that I think through some of her communications with the board, she feels a little bit better about that part. We do have some concerns that in order to sort of determine, or if I'm an attorney trying to help a client determine what their risk to reoffend score might be, that really the only way to sort of use the algorithm in a meaningful way will be to log into a website, is my understanding. And then I think we can punch in the variables, and then it'll generate a risk to reoffend score as we understand the facts at that particular moment. And I know that we may not have access to all of the data that the parole board might. I think it does become a concern that if we have an incarcerated client, or if the client is no longer represented by counsel, and the client is trying to figure out or to test the risk to reoffend score, if the inmate does not have internet access, it's going to be difficult for the inmate to sort of know and be able to potentially challenge a parole decision that's based upon the risk to reoffend score. So without meaningful internet access, or without the lawyer actually being able to come to the jail, because very often, even in the county, it's a rare DOC facility that I can go in with my iPad or laptop and use those tools with an inmate. And very often in the county jail setting, we can't bring that technology in. And so this being a very much online tool, it presents some challenges with internet access. So those are some concerns that we have in terms of moving to this algorithm that really we can't meaningfully, you're asking lawyers to do math, which is a bad problem to begin with. But we appreciate that there's going to be some internet component that we can access to sort of figure some of these things out. But I think for the uncounseled client, and there is no right to counsel in the parole process, there needs to be some provision within the DOC for internet access. And those are really, in summary, the main concerns that we have as we look to the bill. We appreciate the opportunity to come and speak to the board, and we really do appreciate the overall process with what the parole board is doing. We think this does increase the transparency of the parole process beyond what it is right now. We very much appreciate that, and we appreciate the dialogue we have been able to have over the past year with the parole board very much.
Excellent. Any questions for Mr. Key from the members? Any questions at all?
I have a question, Mr.
Do we have a
Chairman.
question? If you'll push your speaker. There you go.
Can you hear me now?
Yes, sir.
Okay. Mr. Key, you said you represent GACTL. Is that the Georgia Association of Criminal Defense Lawyers?
Yes, sir.
Are you in leadership with their big organization?
I'm the president-elect of that organization. I'll be president in January, and I'm the current legislative chair
Okay.
of GSCDL.
Thank you.
All right, thank you.
It's easy question.
Thank you. I got worried. Thank you so much.
We appreciate the comments that you're making today. I think the majority of what you've brought before the board is information that we've been dealing with over the last few weeks, if not months, trying to find reasonable answers to those questions for you. But we appreciate you bringing those back to us.
Thank you.
Okay. Do we have others wishing to make comments on the proposed rule change?
May I add to that, Chairman?
Yes, you may.
Thank you. Good morning, Chairman Bernard and members of the board. My name is Jody Dick. I'm a criminal defense lawyer here in Atlanta. I'm a member of GACTL, and I agree with the comments that Mr. Key has brought to the board's attention. I also want to say that I have extraordinary respect for Director Barnett and his team and the efforts that they have made, certainly that I've seen over the past year, and the changes that they are looking to make over the next year or two. I do, however, have concerns with the proposed amendments to Board Rule 475-3-.05, and as the board is aware, I did submit a written comment addressing those. So I don't want to go over everything that I addressed in that letter, but I do want to touch on a few things. The most significant, of course, is my concern that counting as a factor into the risk score the number of arrests, misdemeanor and felony arrests that are unconvicted arrests, that are arrests that are dismissed, leads to a concern that it violates the principle that is so strong, so important to our society, so treasured, which is the presumption of innocence. There are many reasons why, as Mr. Key mentioned, there are many reasons why people get arrested, and not all of those are valid. False arrests, mis-IDs. We see, for example, with the innocent projects that are around the country, the number of arrests made on bad IDs where men and some women have been in custody for 20 and 30 years of their life because they've been mis-ID'd, and DNA evidence has proven without a doubt absolute innocence in those cases. But that's just a small example. Those are maybe 300 that we have seen nationwide, but there are thousands, and in fact in Georgia, hundreds of thousands of cases that have been dismissed by the state after the state attorney, district attorney, or the solicitor has determined through an investigation that there is not enough merit to go forward with the prosecution of a case. And I say that hundreds of thousands, and I don't use that loosely. I base that on data that I have now received from the Georgia Bureau of Investigation based on an open records request that I've made, and I only received that information a couple of days ago. Initially, when I made the request, I received data that included the number of arrest counts. So, and rather than arrest cycles, which would have been, the number was much greater, 10 times greater, in terms of how many counts are being dismissed every year. But what I did is I limited my request to cases not to include acquittals, not to include cases that were dismissed because of entry or completion into accountability courts, not to include diversion cases that were dismissed, not to include discharge cases through conditional discharge of Title 16 or first offender under Title 42. So I've excluded in my request all of those. In addition, I've limited my request to those arrest cycles in which each and every charge was dismissed. So I'm not looking at an arrest cycle in which a felony charge was reduced to a misdemeanor. I've excluded that. I've excluded cases where there might have been 3 charges and 2 were dismissed and 1 was resulted in conviction. I've excluded that. So we're talking about arrest cycles that are strictly and completely dismissed. And the numbers are, I think the numbers are high. I'm hoping that the board considers those numbers, and I put those numbers in the letter that I submitted yesterday. And I apologize for the lateness of that. I meant to do it much earlier, but with other obligations, it just kept being delayed. In addition to that, I was waiting on the data, like I said, from the GBI, which I did not receive until I think Friday. And I'm looking, and I've got data which I can certainly present to the board at any point. I can provide that to Mr. Barnett if the board is interested. But even if we just look at the last 5 years, 16,500 felony arrests, full arrest cycles dismissed in 2012, 50,000 misdemeanor arrests dismissed. In 2013, 15,000 felony arrest cycles dismissed, 47,000 misdemeanor arrests. 13,000 felony arrest cycles dismissed in 2014 with 42,000 misdemeanor arrests. 11,000 felony arrests dismissed in 2015 and 36,000 misdemeanor arrests. And then in 2016, 6,000 felony arrests with 25,000 misdemeanor arrests. The most compelling, I think, is if we look at the last 10 years, the gross number, total number, over a 10-year period from January 1st of 2007 through December of 2016. And during that 10-year period, again, taking into cases excluding acquittals, cases dismissed because of completion of a pretrial diversion or accountability court program, and only taken into consideration arrest cycles in which each and every charge was dismissed, there were approximately 167,000 felony arrests and 443,000 misdemeanor arrests that were dismissed, for a total of approximately 600,000 cases, complete cases that were dismissed. Those numbers are high, and they indicate and support the proposition that cases are dismissed more often than we believe them to be, that that arrests are not always valid arrests, that arrests are made sometimes on supposition and false accusations. And so I implore the board to consider that. I think that it would be a fairer, a more just approach, and something that would be more consistent with the presumption of innocence, rather than converting it to a presumption of guilt for these people that have had cases dismissed, to change the risk assessment tool, to add in the number of arrest cycles, but to limit it to those cases in which either there is a conviction or a first offender disposition. You can include first offender dispositions, you can include accountability courts, you can include conditional discharge, you can include all of those things, because all of those things are indicative of some culpability. An arrest without anything more does not indicate or prove or establish any degree of culpability. So if the board were to consider the number of arrests, felony or misdemeanors, but to limit it to those cases in which there's a disposition indicating culpability, then that would be, again, a more fair and a just system. It would not penalize people for being falsely arrested, and it would be consistent with the principles that are so important to our society, which is presumption of innocence. I think Mr. Key covered the other issues. I don't think there's anything else I need to add except one thing, and this was a suggestion that was made part of the letter that was submitted to the staff, the parole staff, back in October, when we were first made aware of some of the changes that were being proposed, and that is counting DRs and violent DRs into the risk score. And our proposal at that time, which I still believe is a valid one, is if the board is going to factor in violent DRs, especially if the board is going to include violent DRs in which there's been no disposition addressing culpability, then at the very least, what we're asking the board, what I'm asking the board to do, is to allow or to consider rolling off the DRs after a certain period of time, so that, for example, maybe in the factor where we're including whether or not a person has a violent DR in the past, maybe it could be split into in the last 5 years or in the last 10 years, so that those older DRs are rolled off, especially the ones in which the person has been found to be acquitted. I don't know the exact term, but to be acquitted of that charge, or sometimes not even fully processed. There are cases for DRs, for example, where the person is charged and there's no further action taken in the corrections system. So those are my thoughts, and I appreciate very much the opportunity to address the board. Thank you.
Let's see if there's any questions, Ms. Dick, before you leave. Is there a question from the board? Let me, just for a point of a clarification on this, on your argument for presumption of innocence, are you recommending that the board actually go to arrest in their risk assessment rather than convictions, or convictions rather than arrest? Is that what you're making the suggestion? Is that correct?
That's correct,
Chairman
Bernard.
So you're basically stating that we should maintain the same standard that we're using now, which we have used.
Actually, no, very different one. The
Then,
standard, may I address that?
yeah, please.
Thank you. The standard that is used now is the number of conviction counts that a person has, which I actually think is also an unfair one. Because if you look at a person, if you look at two people, one person that has 5 prior felony convictions, that person presently under the tool now used, the person who has 5 prior felony convictions, let's assume each one has 1 count. That person will be counted as having 5 conviction counts. The person who's got 1 felony arrest in their whole life, but it happens to have multiple counts, because often district attorneys will charge alternative counts. That person will be risked equally for that category, even though they're completely different situations. What I think is the most fair is to look at arrest cycles, and where it says conviction counts, I don't know if I don't actually know the answer to this. I don't know if the present tool counts conviction counts and also includes first offender, conditional discharge, accountability court, dismissals. I'm completely okay with all of those, because all of those suggest some degree of culpability, even those cases that are dismissed. So it's actually broader to some extent than the tool that is presently used, because it's including not only convictions, but also dispositions in which there is some degree of culpability. Those are all coded. Those are not difficult to ascertain, because they, each and every one of those has a specific code that is put in by the clerk based on a list that is provided by the GBI and the GBI division on the GCIC division. They have codes for each offense. So it's actually broader, but it's also limited to, instead of conviction counts, we're looking at conviction cycles. So that, if we're going to judge, I guess the point is, the point is to judge and predict bad behavior, then it should be behavior that is bad. Innocent behavior is not bad. Innocent behavior is merely innocent.
Okay.
Thank you.
Any questions? Thank you for your comments.
Thank you.
Are there any other people wishing to speak or make comments concerning the proposed rule change to our guidelines process? Yes, ma'am. Would you come to identify yourself and come to the microphone?
Good morning.
Good morning.
My name is Karen James, and I am a family member of an offender. So I come to you on behalf of families, and a family that has been impacted by the rise in numbers of gang members in the facilities. My comments, some of them may be more appropriate for the Department of Corrections as opposed to pardons and paroles, but I'd still like to.
We'll have them on the record if you wish to go ahead and speak those.
So thank you for the opportunity to speak regarding the proposed guidelines for the Georgia Parole Board. There is definitely a problem with gangs in the systems that needs to be addressed. Perhaps this is a step to address the issues that appear to put it in the hands of the inmates. Self-control, right choices, etc. Prosecutors and judges have waged a very aggressive war on gangs to keep our communities safe, and presented GDC and the Department of Corrections with a huge problem with the large number of arrests. As we know, there is understaffed and lack of training to deal with gangs that has created a serious problems in our institutions. A few years ago, I met a social worker from California, and she stated to me that upon release from jail in California, there was a concerted effort to send a number of gang members down south. Suppose perhaps we could return the favor. From the time that I have encountered issues with Department of Correction involving gang members, it has been a sobering experience, to say the least. when you're out on the street, you can make a choice if you want to be involved with the gang or not, or you can disassociate yourself in terms of where you go and how you carry yourself. You are limited when you're in a controlled environment there. So I would just like to put that on the record for whoever is considering and thinking of things in terms of gang members. But my question, and I heard the gentleman ask the question or talk about it when I came in, how will the validation of gang members be done? What is that process? What are the gangs we're talking about? Are they official gangs, or is it what I've heard the legal term for gangs is 3 or more people doing various things, committing crimes. What is the process that allows known gang members to get out of the gang safely? And if you were previously in the gang and you have gotten out, is that taken into consideration? Will that be taken into consideration? And a novel idea, what about recognizing those who have no gang affiliation in some way? So those are just some of the questions that I had concerning this process. I'll just end with this. As we know, there are a large number of incarcerated men and women that will be released back into our system, into our society. And the goal should be to return people that are whole and will not return back to the prison life. So I believe that everything that we can do as a society, as a board, as a governing board, should be done to assist people who might, for whatever reason, found themselves in the gangs or have been victims of those gangs. Thank you.
Thank you. Any questions from the members? No questions. Thank you much for the comments. Anyone else wishing to speak on behalf of the proposed amendment to the board's rule change affecting our guidelines process? Yes, ma'am. If you'll come to the podium and address yourself.
Hello. I am a family member of an incarcerated inmate. I'm from out of state, so please excuse me. Okay, so
Would you give us your name?
my name is Bernicia Womack.
Thank you.
Okay. My daughter's father has been incarcerated, and he had no prior felonies. But it's the act that he actually, what he got arrested for, he ended up getting 25 years. He is a college graduate, and he also was a veteran. He did have PTSD, and that was also documented. There was other things that were going on with him that was documented, but it wasn't considered into the case when he was when he went to court. And I'm thinking that there has to be something in place that actually creates fairness among the people that are being incarcerated. Just like the young lady was saying, as far as the charges, if they're having one offense and they have several different charges for that one offense, opposed to someone that has had numerous arrests and different felonies. And then also along the lines of taking into consideration things that they have done within the community as well. Because he did have a non-for-profit for veterans and whatnot, but he's actually been put into a system where he's taken out of the community, taken out of doing something that's positive for the community as well, and put in prison for 25 years where he's supposed to serve 15. And as well, being taken away from our child, our daughter, who they did have they had a strong type of relationship to where he was making sure that he was in her life. I think those type of things should be taken into consideration when young men or women are being sentenced, because we're taking people that are actually doing something good and positive, and then trumping these charges and then arresting them for long periods of time. Now, I don't know if I'm saying this all correctly, but I just, want to kind of speak out about this. And also, because I know he's probably not the only person that this has happened to. And this is greatly affecting my child. And I know that there's other children that are being affected in the same way. And it's a continual cycle that eventually it disrupts the community as well. And you have all these children whose parents are taken away from them, and they're not, and their actual complete life opposed to the charges is not being considered when they're being sentenced. And then even the fact that he's been in there for 5 or 6 years already, and instead of his charges being, where he can serve, they were being run at the same time concurrent. He had them back to back, so he's in there for a longer period of time. And also, just kind of, making it to where, like, say, for instance, if he's in prison and somebody says, oh, well, he's doing something wrong, at least having the proof to where he's not a maximum security, or he's just or anybody along those lines. They're not just being fingered as doing something wrong, and then that word is being taken, and then they're put into another type of system that they weren't doing anything, they're pretty innocent. So I just wanted to kind of address you all and see if there's something that can be done to create that fairness, create the understanding of somebody has been a veteran, has PTSD, that there's something that can be put into place that would actually help them, opposed to just locking them away for 25, 30 years, or if there's programs that are put in place for somebody, like, let's say, for instance, if you go get your GED, then you have a certain amount of time that's taken off your sentence. Well, somebody's in there that was in college, or that was in college or already had their GED or graduated with their diploma, what type of programs are put in place for them to where they can get their sentence reduced as well.
Okay, thank you much. Anyone else? Any other person wishing to speak or make comments on our proposed rule change? Going once, twice? Then our segment for public comments has now closed. The matter will now come before the board. There will be no other opportunity for public comments prior to the board making its decision, as I see it at this very moment. Just a second. So, LaCondra, let me make sure, Quan, that sounds weird calling you by your legal name. So as I hear it, the only written comments that came in was also verbalized to us today. So we have no other public comments other than what we heard today. Is that correct?
That's correct, sir.
Okay. So the board is in this position. It provisionally adopted the rule change last month. Today would be to ratify that rule change if the board should choose to do so. Any substitute motion other than a motion to ratify at this time? So is there a motion that we adopt the rule change?
You have your motion.
We have a motion to adopt. Is there a second?
Second.
There is a second. All in favor say aye.
Aye.
Any opposed, like sign. It appears that the rule change has been adopted. Thank you. Thank you very much. Okay, we'll move now to our next section, which would be new business. And I think we've got 6 policy changes that are pretty much housekeeping. And I'm going to ask Chris to come and just briefly give us a brief synopsis of all of those 6 in one speaking. And if there is any one particular for the board, if there's any one particular of that 6 that you wish to be taken off the rostrum and voted separately, at the conclusion of this, let me know, and then we'll go back and look at that separately. Otherwise, we'll vote them straight up or down as a package. Begin.
Sir, first board policy up for proposed policy change is board policy 1.102, victim compensation program. Section 1.106.3, reference to code operations manual has now been changed to as outlined by the DOC CDO administered by DCS, as field operations manual no longer exists. Second, board policy 1.105, firearms, section 1.105.1.2. There was a terminology removed as a result of the field operations manual no longer being in existence. There's also no longer specified, this is no longer specified in the new operations manual. Also, in 2 other locations within policy, reference to that field operations manual has now been updated to the current title of Pardons and Paroles Operations Manual. Third, board policy 2.101, authorization to serve board warrants and to arrest without a warrant. Section 1.106.2, reference to field operations manual has again been updated to the current title. The fourth board policy 2.108, reporting violations of out-of-state releases in sections 1.106.1 and 1.106.2. Again, reference to field operations manual has been updated in title, and in 2 other subsequent sections, reference to the field operations manual was removed completely. In the fifth board policy 2.114, local detention use. The policy heading, Director of Field Operations, was changed to current title, Director of Field Services. And in section 1.105, the term parole officer has now been updated to supervising officer or employee of the board. In the final board policy 3.130, employee assistant program, in the policy heading, in addition to being under Director of Human Resources, it's under also the EAP coordinator. All references to the field operations manual again has been replaced to the board operations manual current title. 1.104.3, office number has been updated for the EAP coordinator. 1.106.6, human resource director was now added to list of individuals in which the record of conversation or personal problems from another employee can now remain confidential. A sentence was also added in that section that addresses the storage of psychological and or psychiatric exams. A new section was also added, section 1.106.7. This section outlines informed consent and release of information authorizations. The following section, terminology including critical incident response and coordinating procedures, was added when considering a critical incident debriefing. In another following section, a new section was added to allow the EAP coordinator to counsel employees who self-refer for assistance. And another new section and 3 subsequent subsections were added at the end of the policy to address the psychological re-examination requirements. And as a result of these new sections being added, all affected sections were renumbered as a result. That concludes all 6 board policy revisions.
Okay, any member wishing to pull any one of these 6 off and vote separately? If not, is there a motion to adopt all 6 of them as presented by Chris?
Move we adopt.
There's a motion. Is there a second?
Second.
There's a second. All in favor say aye.
Aye.
Motion carries. Those policies have been adopted. Thank you much. Mr. Director, do you have anything to report today?
In consideration for time, I'll withhold my comments till next.
Very good. Well, Director passes. Let that be a monumental statement. At least it's on the record that you did once in your life. All right, we'll move into general public comments, and at this time, the board will hear any particular public comments that anyone wants to make concerning any of the initiatives today. We've obviously taken care of our public comments on the rule change, but of the other policy changes, other than the board will actually hear from at this time. We'll not actually hear on individual cases. If you have individual cases that you wish to have comments or questions, we have a call line. That call line is 404-656-4661. Any public comments other than personal cases? No personal comments. Then I guess we'll accept the motion to adjourn. Is there a motion?
Move we adjourn.
There's a motion. Is there a second?
Second.
There is a second. All in favor say aye.
Aye.
We are now adjourned. Thank you much.